I, me, myself, or myself, I, me, my, or myself, also known as Derek Chaton, House of Gonzalez, having been duly put under oath, I do affirm, depose, and being cognizant of the penalties for bearing false witness, do say, all the facts herein stated are true, correct, complete, and are not hearsay, are not misleading, but are admissible as evidence, and if called to testify, I shall state, and further, I have standing capacity to act as to the lawful matters herein, and further, I have personal first-hand knowledge, executive and documented knowledge of the facts stated herein, and further. Dang it, why does it keep doing that? I am currently an inhabitant of the land, sometimes known as Nebraska, whatever you want to put there, doesn't really matter. And I have no first-hand knowledge of my date of place of nativity. Any evidence anywhere about my birth is hearsay evidence and inadmissible evidence in any court, because both my mother and father and the attending physician involved in my entry into this world, I have not had an opportunity to cross-examine them in a court to determine the veracity of any evidence they may have been able to give. Having said that, I do remember that I acquire my... Yeah. I'm a sovereign living soul, sentient being, and a holder of the office of the people, and having private core judicial rights, power citizens by right of blood as described in a corporate denial affidavit, which is recorded, and all subsequent superseding documents, all of which is incorporated herein by reference in its entirety, and all of which is now the unrebutted truth and public policy. And further, I am not in the military. The use of my of any statutes, codes, rules, regulations, or court citations within my documents created by me at any time is only to notice that which is applicable to government officials, and is not intended, nor shall it be construed to mean that I have conferred, submitted to, or entered into any jurisdiction alluded to thereby, and further. 8. Equality under the law is paramount and mandatory by law, and further. The process of this document is to establish the fact that all bar members are foreign agents, and therefore enemy agents. First, we must establish that bar members are all foreign agents of Crown, and A, Crown is a corporation domiciled in the city of London in England, and B, the Crown has nothing to do with Queen Elizabeth, because if it is Queen Elizabeth's crown, it will have an ER superimposed over it, which stands for Elizabeth Regina. And C, the city of London is foreign to the rest of England, just like the District of Columbia is foreign to the rest of the United States of America. The United States government is a foreign corporation with respect to a state of the Union. In regards to Merriam's estate, 36 NE 505 141 NY 479 affirmed, 16 S period CT 1073 41 L period ED 287, and D, the City of London is a walled-in part of downtown London, England, approximately 2 square miles, and there are 12 gates, and it contains the Imperial Parliament building, and E, William the Conqueror conquered all of England except for the City of London, and F, periodically they show the convening of the Imperial Parliament on television, and it is very telling about the nature of the City of London, because the Queen goes to one of the gates called Temple Bar, which is essentially a big oak door with a foot square small door in it, and both doors are closed, and the Queen beats on the door with her scepter, and the Lord Mayor of London on the other side of the door opens the small door and asks the Queen what she wants, and she has to get permission to enter the foreign territory of the City of London, and while she is in there, she walks 2 steps behind Lord Mayor of London, and with her head bowed, because she is not a sovereign in there. And G, there are 4 law schools in the City of London, and one of them is called the Inns of Court. Inns of Court, these are certain private unincorporated associations in the nature of collegiate house located in London, and invested with the exclusive privilege of calling men to the bar. Black's Law Dictionary, 5th edition, page 709, emphasis added. And H, here is the American Inns of Court, and there are chapters in every state in America. Therefore, all bar members owe their allegiance to the Inns of Court, which is a foreign power. And further, 10. Because King John needed to raise money at the time he imposed martial law rule, A, there are 3 kinds of martial law. 1, full martial law, soldiers on the streets, used only in foreign countries or to put down an insurrection. 2, martial law proper, the law of the armed forces. And 3, martial law rule, the law of necessity and emergencies used during peacetime, etc. Ex parte Milligan, 4 Wall 71 U.S. 2 18 L period ED 281, page 302, emphasis added. B, the law of emergency and necessity was used to impose martial law rule in England in 1213, just like criminals in the United States use the law of emergency and necessity to impose martial law rule today. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat. 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. House Joint Resolution 192, 73rd Congress in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacity of all United States governmental officers, and departments, and in further evidence that the United States federal government exists today in name only, United States Congressional Record, March 17, 1993, Volume 33, emphasis added. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operations of private enterprises, restrict travel, and, in the plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedom and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by state of national emergency. In regards to U.S. Senate Report number 93-549, dated 11/19/73, 73 CIS serial set S963-2, 607 pages. What is called proclaiming martial law is now at all is no law at all, but merely for the sake of public safety. In circumstances of great emergency, setting aside all law and acting under military power, 8 Attorney General OP 360 8 Attorney General Opinion 367, February 3rd, 1857. And the Magna Carta is full of evidence of martial rule being imposed in England, including but not limited to 1, Chapter 13, where they were charging fees and harassing people customs under the color of law, martial law, to enter into the City of London, foreign territory, under the second part of Chapter 13. And the City of London shall have all its ancient liberties and free customs, all while by land as well as by water. Furthermore, we decree and grant that all other cities, boroughs, towns, and ports shall have all their liberties and free customs. 2. And Chapter 23, where their martial law shocked troops under the color of law, martial law dictatorship, where forcing people and villages to build bridges. No village or individual shall be compelled to make a bridge at riverbanks except those who from of old were legally bound to do so. 3. And chapter 24, where their martial law shock troops were holding hearings without a judge under the color of law, martial law dictatorship, and it is exactly what they do when their hired thugs unlawfully arrest you on the road today. No sheriff, constable, coroners, or others of our bailiffs shall hold pleas of our crown. 4. And chapter 28, where their martial law shock troops were stealing corn and other provisions under the color of law, fascist PayPal martial law dictatorship, without paying for it. No constable or other bailiff of ours shall take corn or other provisions from anyone without immediately tendering money thereof, unless he can have postponement thereof by permission of the seller. 5. And chapter 30, where the martial law shock troops were stealing horses and carts based on their trumped up charges for transportation duty under the color of law, PayPal fascist martial law dictatorship. No sheriff or bailiffs of ours or other person shall take the horses or carts of any freeman for transport duties against the will of the said freeman. 6. And chapter 31, the martial law shock troops were stealing wood under the color of law, martial law dictatorship. Neither we nor our bailiffs shall take for our castles or for any other work of ours wood which is not ours against the will of the owner of that wood. 7. And chapter 38, where they were imposing their private PayPal fascist martial law upon the people under the color of law, martial law dictatorship, which is exactly what they do when their hired thugs issue a citation or a traffic ticket, or their hired thugs stop you at the so-called border. No bailiff for the future shall, upon his own unsupported complaint, put anyone to his law without credible witnesses brought for their purpose. 8. And chapter 39, they were imprisoning people, stealing their property, violating their rights under the color of law, martial law dictatorship. No free man shall be taken or imprisoned or deceased of it, or exiled, or in any way destroyed, nor will we go upon him, nor send upon him, except by the lawful judgment of his peers, or by the law of the land. 8. 5, 6, 7, 8, 9. 9. And chapter 40, where they were charging fees for their so-called justice, filing fees and other fees and regulations, denying access to justice by making rules, regulations, and fees under the color of law, PayPal fascist martial law dictatorship. And this is all going on today in their so-called courts at the hands of judicial whores who intended to sell their so-called justice. To no one will we sell, to no one will we refuse or delay right or justice. 10. Chapter 45, where officers of the court and other officials were ignoring the law and violating the rights of the people under the color of law, martial law dictatorship, and this chapter was inserted to create the presumption that the officers of the court and other officers are presumed to know the law. We will appoint as justices, constables, sheriffs, or bailiffs only such as know the law of the realm and mean to observe it well. 11. Chapter 55. They were imposing fines and other sentences under the color of law, PayPal fascist martial law dictatorship. All fines made with us unjustly and against the law of the land, and all armaments imposed unjustly and against the law of the land shall be entirely remitted. D. And martial law is under Roman law, because civil law and Roman law and municipal law are convertible phrases. Civil law, Roman law, and Roman civil law are convertible phrases, meaning the same system of jurisprudence. That rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of the land, and the law of nature, and from international law, see Boyer Mode Civil Law 19, Seaver versus Riley, 189 California, 170, 244, P. 323, 325, Black's Law Dictionary, Revised 4th Edition. Admiralty law. The terms admiralty and maritime law are virtually synonymous. Black's Law Dictionary, 6th edition, 1990. Civil law, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly distinguished by the name of municipal law. The Dictionary of English Law, Sweet and Maxwell, Ltd., London, 1959. There must be a uniformity in maritime law. The principle of maritime laws are applicable to commercial law, and therefore there must be uniformity in the commercial law. Swift versus Tyson, 16 PET 1, 1842. And the forms and modes of proceedings in causes of equity and of admiralty and maritime jurisdiction shall be according to the civil law, Wayman and others, and another versus Sutherland and another, 10 Wall 1 P 317. And under the Vatican Concordat, the wearing of the clerical dress or of a religious habit by someone not authorized is punished by death by firing squad, because in the military such people are treated as spies and summarily executed, which is further proof that martial law comes under Roman law. The wearing of clerical dresses or of religious habit by lay people or by members of the clergy or religious orders by whom this use is forbidden by a definitive and legal valid directive of the competent ecclesiastical authority and officially communicated to the state authority is liable to the same penalty by the state as the muses of the military uniform. Article 10, 1933, Concordat with the Vatican, emphasis added. E. And the objective was for military law rule to eliminate common law, and one of the ways they do that is by seizing all of the gold. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89, 719, declared by President Roosevelt, being bankrupt and insolvent. House Joint Resolution 192, 73rd Congress, in session June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacity of all United States government officers and departments, and in furtherance, evidence that the United States federal government exists today in name only. United States Congress, Congressional Record, March 17, 1993, Volume 33. Because at the common law, only gold and silver coin is legal tender. At the common law, only gold and silver were a legal tender. 2 Institutes of American Law, 577, McLaren versus Nesbitt. 2, Not and McSee. 11 S.C.L, 519, 1820. And while they could not completely eliminate gold and silver coin, they could compel all of their bankster-owned and operated corporate commercial thugs to use their IOUs, Federal Reserve notes, which they did with the Gold Reserve Act of 1934. Section 15, as used in this act, the term United States means the government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes United States notes, Federal Reserve notes. Damn it, I did it again. Federal Reserve notes, Gold Reserve Act of 1934, 48 Stat 337, which technically says that the Federal Reserve notes, IOUs, are meant for internal government use only, but because all corporations are subject to government regulation, they are also agencies of the government, and they are compelled to use Federal Reserve notes as well. The Federal Reserve notes are legal tender and therefore forced loans. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States. Juilliard versus Germain, 110 U.S. 432. and Federal Reserve notes are also bills of credit. The said notes shall be obligations of the United States, Title 12 U.S.C. subsection 411, and also Title 18 subsection 8. And Federal Reserve notes are not promissory notes because there is no promise to pay. Therefore, they can only be IOUs. Promissory notes, contracts, a written promise to pay a certain sum of money at a future time unconditionally, 7 Watts and S period 264 and 2 Hump HUMPH are 143.10 Wednesday 675 minor R period 263, 7 Missouri 42 2 Cohen 563 or 536 6 NHREP 364-7. Vern 22. A promissory note differs from a mere acknowledgement of debt without any promise to pay, as when the debtor gives his credit an IOU. Q period V period C2 Yeager or Yerg YERG 50 15 M period and W period 23, but C 2 HUMPH 143.6 Alabama R 373. Bovier's Law Dictionary 1856 edition, emphasis added. And anyone who used Federal Reserve notes to purchase something is using United States Inc. credit, and they are saying that they are a United States citizen, and a United States citizen is a fraud and a fictitious entity and a slave, as described in the corporate denial affidavit, which is recorded with the and all subsequent superseding documents, all of which is incorporated herein by reference in its entirety, and all of which is now the unrebutted truth and public policy. And they're saying that they are a pauper because they are using IOUs to purchase something. The better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall free ingress and regress and egress to and from any other state. Article 4 of the Articles of Confederation. And at common law, pauper has no rights. Pauper, one so poor he must be supported by and at the public expense. Bovier's Law Dictionary 1856 edition. Pauper, a very poor person, is ESP, one who receives aid from charity or public funds. Black's Law Dictionary 8th edition. And United States Inc. owns whatever was purchased, which is why there is a tax tribute. And since the bankster thieves own the United States Inc., as described in the corporate denial affidavit, and all subsequent superseding documents, all of which is incorporated herein by reference in its entirety, and all of which is now the unrebutted truth and public policy. They have effectively stolen everything. F. And the big reason they want to eliminate common law is because there is no common law judicial immunity, and they intend that the bar member judicial thugs have immunity for the crimes that their crown handlers intend that they commit. Dang it, did it again. There is no common law judicial immunity. Pullum versus Allen, 104 S period CT period 1970. And there is no qualified immunity or any other immunity at common law for their color of law code enforcers that their bar members owned and operated corporate commercial de facto so-called courts have given them. G. And as they intended, their martial law rule eliminated common law when it precipitated the War of Independence, just like it eliminates common law today. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law. thereby destroying the common law and leaving what is called equity in its place. Diet versus Turner, 439 P2D 266 at 26920 UTD 403 1968. The non-ratification of the 14th Amendment by Assistant Director A.H. Ellett, Utah Supreme Court. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us, the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of the common law, and instead, therefore, and thereof, to publish and alter the use and exercise of the law martial, and for the altering fundamentally the form of government established by character, we saw the misery to which such despotism, military dictatorship would reduce us, cause and necessity for taking up arms, 1775. That the respective colonies are entitled to the common law of England, and more especially to the greater and inestimable privilege of being tried by their peers of the vicinage according to the course of that law. Resolved that the following acts of Parliament are infringements and violations of the rights of the colonists, and that the repeal of them is essentially necessary in order to restore harmony between Great Britain and the American colonies, viz. The several acts of 4 GEO 3, Chapter 15, and Chapter 34, GEO 3, Chapter 25, 6 GEO 3, Chapter 52, and 7 GEO 3, Chapter 41 and 46, and 8 GEO 3, Chapter 22, which imposes duties for the purpose of raising a revenue in America, extend the powers of the admiralty courts beyond their ancient limits, deprive the American subject of trial by jury, authorize the judge's certificate to indemnify the prosecutor for damages that he might otherwise be liable to, requiring an oppressive security from a claimant of ships and goods seized before he shall be allowed to defend his property, and are subversive of American rights. Declaration and resolves of the First Continental Congress, October 1774, and the Foreign Enemy Agent Bar member in the legislature and U.S. Congress know that common law is eliminated because they pass statute for common law crimes, like common law crime of misprison of a felony. Misprison of a felony, the offense of concealing a felony committed by another, but without such previous concert with a subsequent assistance to the felon as would make the party concealing any accessory before or after the fact. Fourth STEPH Commentaries on Law 260, Fourth Blackstone's Commentary on Law 121, United States versus Pearlstein, CCANJ 126 F period 2D 789 798, Black's Law Dictionary 4th edition, page 1152, which is codified at Title 18, subsection 4, whoever having knowledge of an actual commission of a felony cognizable by a court of the United States conceals or does not, as soon as possible, make known the same to some judge or other person in civil or military authority under the United States shall be fined under this title or imprisoned not more than 3 years, or both. Title 18 USC subsection 4. And the common law crime of barratry. No action can be taken against a sovereign in the non-constitutional courts of either the United States or the state courts, and any such action is considered the crime of barratry. Barratry is an offense at the common law. State versus Batson, 17 S period E period 2D 511 512 513. A person commits an offense if, with the intent to obtain an economic benefit, the person 1 knowingly institutes a suit or claim that the person has not been authorized to pursue, and B, a person commits an offense, and D, a person commits an offense if the person 1 is an attorney, chiropractor, physician, surgeon, or private investigator licensed to practice in this state, or any person licensed, certified, or registered by a health or care regulatory agency of this state, and Texas Penal Code Section Point 12, Barratray and solicitation of professional employment, emphasis added. And they have to pass statutes making common law the rule of decision. The rule of decision in this state consists of those portions of the common law of England that are not inconsistent with the Constitution of the laws of this state, the Constitution of this state, and the laws of this state. Texas Civil and Practice Code, Section 5.001, Rule of Decision, emphasis added. When they know that the common law is already the law of the land and has already been the law of the land and will always be the law of the land, the individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbor to divulge his business or to open his doors to an investigation, so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom. Beyond the protection of his life, liberty, and property, his rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure except under a judicial power warrant, a warrant of the law. He owes nothing to the public so long as he does not pass upon their rights. Hale versus Hinkle, 201 U.S. 43. Because under the martial rule, there are no crimes, and they conveniently forgot to make statutes for common law crimes like infanticide, because the bar members in the legislature and U.S. Congress intended to support the Crown's policy of population reduction. And the bar members in the Supreme Court come out with rulings allowing their U.S. citizen slaves to murder their unborn children. The unborn are not included within the definition of person as used in the 14th Amendment, Roe v. Wade, U.S. Supreme Court 410 U.S. 13, 35L, ED, 2D, 147, 1973. By the way, the reason that Roe v. Wade is going to be overturned is based upon a technicality. Roe never gave permission for the lawyers to bring claim. They didn't have standing, and that's why it's going to be overturned. It has absolutely nothing to do with the merits of the case and everything to do with the fact that they didn't have jurisdiction and that Roe never gave her explicit permission to the attorneys to bring claim on her behalf, which also exposes the bar members' agenda to commit genocide against state citizens in America, because if the unborn are not persons, they are murdering state citizens who are also not a person, as described in a corporate denial and all subsequent superseding documents of all which is incorporated herein by reference in its entirety, and all of which now the unrebutted truth and public policy, H, which is the exact same reason for the War of Independence, and evidence of that fact is found in the cause and necessity of taking up arms, 1775 Declaration of Resolves of the First Continental Congress, October 1774, and Declaration of Independence, 1776, behold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted amongst men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such forms as to them shall seem most likely to affect their safety and happiness. But when a long train of abuse and usurpation pursuing invariably the same object, evidence and design to reduce them under absolute despotism, military dictatorship, it is their right, it is their duty to throw off such government and to provide new guards for their future security. The history swallowed a bug. The history of the present King of Great Britain is a history of repeated injuries and usurpation, all having a direct object, the establishment of an absolute tyranny, military dictatorship over the states. To prove this, let facts be submitted to a candid world. He has affected to render the military independent of and superior to the civil power, military dictatorship. He has combined with others to subject us to a jurisdiction of foreign to our Constitution, military dictatorship, and unacknowledged by our laws, giving his assent to their acts of pretended legislation, color of law, for protecting them by a mock trial, military dictatorship, from punishment for any murders which they should commit on the inhabitants of these states, for imposing taxes on us without our consent, military dictatorship, for depriving us in many cases of the benefit of a trial by jury, military dictatorship, for transporting us beyond seas to be tried for pretend offenses, color of law, military dictatorship, for abolishing the free system of English law in a neighboring province, establishing therein an arbitrary government, military dictatorship, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule, military dictatorship, into these colonies, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the form of our government, military dictatorship. He has dictated governments here by declaring us out of his protection and waging war against us, military dictatorship, Declaration of Independence, 1776, emphasis added. And the Crown Bar members are used to enforce their martial law rule. And further, 11, the Founding Fathers knew about the dangers of the Crown Bar members posed in the support of the military dictatorship and the things that would be necessary to bring about military dictatorship, and they tried to prevent bar members from being able to hold any positions of trust, requires an oath of office with no state without the consent of the United States in Congress assembled shall send any embassy to or receive any embassy from or enter into any conference, agreement, or alliance or treaty with any king, prince, or state, nor shall any person holding any office of profit or trust under the United States of any of them, except of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state, nor shall the United States and Congress assembled or any of them grant any title of nobility. Article 4, Articles of Confederation, emphasis added. No title of nobility shall be granted by the United States, and no person holding any office of public or trust under them shall, without the consent of Congress, except of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. Constitution for the United States of America, Article 1, Section 9, Clause 8, emphasis added. And they continue to have bar member problems because they further ratified the true Article 13 in amendment, which says, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present pension, office, or emolument of any kind whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them, or either of them, emphasis added. As taken from a certified copy of the 1819 Constitution for the United States of America, taken from Virginia statutes, a true copy of which is attached to the affidavit of criminal complaint, which is recorded, and the affidavit of criminal complaint, which is recorded, all of both of which are incorporated herein by reference in their entirety, and all bar members receive an honor from a foreign power based on in London, England, and the city of London is a foreign state, as described herein. Title, person, titles are distinctions by which a person is known. The Constitution of the United States forbids the tyranny by the tyrant by the United States or any state of any title of nobility. Judges and members of Congress that are honorable, and members of the bar and justice of the peace are called esquires. Copper Justinian 416, Brackenridge Law, Missel Index, Bovier's Law Dictionary, 1856 edition, emphasis added. And all bar members receive a title of nobility. Nobilitas est duplex, superior et inferior. 2. Institutes on Law 583. There are two sorts of nobility, the higher and the lower. Black's Law Dictionary, 4th edition, page 1198, emphasis added. Esquire, a title applied by courtesy to officers of almost every description, to members of the bar and others. 2. In England, it is a title next above that of a gentleman and below a knight. Bovier's Law Dictionary, 1856 edition, emphasis added. And further, 12. Every state has a state bar, which is governed by the state Supreme Court. A. The Board of Examiners, acting under the instruction of the Supreme Court as provided by this chapter, shall determine the eligibility of candidates for examination for a license to practice law in this state. Texas Government Code Section 82.004, Board Duties, emphasis added. In this subchapter 4, state agency includes A department, commission, board, office, or other state governmental entity in the executive or legislative branch of the state government. B, the Supreme Court of Texas, the Court of Criminal Appeals of Texas, a court of appeals, the Texas Judicial Council, the Office of Court Administrators, administration of the Texas justice system, the State Bar of Texas, or any other state governmental entity in the judicial branch of state government. And C, a university system or an institution of higher education as defined in section 61003 Education Code. And D, any other state governmental entity that the comptroller determines to be a competent unit of state government for the purpose of financial reporting under sections 403.013 Texas Government Code, section 403.242 definition. And there are statutes requiring all judges to be bar members. A municipal court of record is presided over by one or more municipal judges. B, the governing body shall be by ordinance appoint its municipal judges. C, a municipal judge must 1. Be a resident of the state, 2. Be a citizen of the United States, 3. Be a licensed attorney in good standing of the bar, and 4. Have 2 or more years of experience in the practice of law in this state. Texas Government Code Section 30.00006, judge, emphasis added. To qualify for appointment as an associate judge under this subchapter, a person must 1. Be a resident of the state and one of the counties the person will serve. 2. Have been licensed to practice law in the state for at least 4 years. Texas Government Code Section 54A.003, qualifications, emphasis added. And even a federal judges are bar members. No individual may be appointed or reappointed to serve as a magistrate judge under this subchapter unless 1. He has been for at least 5 years a member of the bar in good standing and of the bar of Title 28 U.S.C. Subsection 631B1. And all bar prosecutors are members. A, an assistant prosecuting attorney must be licensed to practice law in the state and shall take the constitutional oath of office. Texas Government Code Section 41.103, assistant prosecuting attorney, emphasis added. And the Court of Criminal Appeals of Texas, the various courts of appeals, the Texas Judicial Council, the Office of Court Administration of Texas Judicial System, the State Bar of Texas, and the Judiciary Courts of the State of Texas, Incorporated, and its parent corporation, State of Texas, Inc., as founded in the Affidavit of Denial, which is recorded, a true copy of which is attached here too, all of which is incorporated herein by reference in its entirety, which is now public policy, and they are all unconstitutional delegations of authority. The governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. Luther versus Borden, 48 U.S. 1, 12 LED 581. A delegate cannot delegate. An agent cannot delegate his functions to a sub-agent without the knowledge or consent of the principal. The person to whom an office or duty is delegated cannot lawfully devolve the duty of another unless he be expressly authorized to do so. 9 Coke, 77, Broom Maximum, 840, 2 Kent, Commentary on Law, 633, 2 Steph, Commentary, 119, emphasis added. A delegated power cannot be, again, delegated. Second Institutions of American Law, 597, Blacks, 2D, 347, 2 Bouvier's Institution on American Law, 1300. A deputy cannot have or appoint a deputy. Story AG S period 13, 9 Coke, 77, Second Bouvier's Institution on American Law, 1936. Therefore, they have no authority. An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protections, it creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. Norton versus Shelby County, 118 U.S., 425, page 442. And they are all criminal racketeering enterprises. As used in this chapter, 1, racketeering activity means A, any act or threat involving murder, kidnapping, gambling, arson, robbery, bribery, extortion, which is chargeable under state law and punishable by imprisonment for more than 1 year. B, any act which is indictable, under any of the following provisions of Title 18 United States Code, Section 1341 relating to mail fraud, Section 1503 relating to obstruction of justice, Section 1581, 1592 relating to peonage, slavery, and trafficking in persons, Section 1951 relating to interference with commerce, robbery, or extortion, Section 1952 relating to racketeering, Section 1957 relating to engaging in monetary transactions and property derived from specified unlawful activities, Section 2421 through 2424 relating to white slave trafficking, Title 18 USC subsection 1961. A, whoever, as consideration for the receipt of, or a consideration for a promise or agreement to pay anything of pecuniary value from an enterprise engaged in racketeering activity, or for the purposes of gaining entrance to, or maintaining, or increasing position in an enterprise engaged in racketeering activity, murder, kidnap, maims, assaults with a dangerous weapon, commits assault resulting in serious bodily injury upon, or threatens to commit a crime of violence against any individual in violation of the law of any state or the United States, or attempts or conspires so to do, shall be punished under Title 18 USC subsection 1959. And they and their hired thugs, color of law code enforcers, are criminal street gangs. A, combination means 3 or more persons who collaborate in carrying on criminal activities, although 1, participants may not know each other's identity, 2, membership in the combination may change from time to time, and 3, participants may stand in a wholesaler, retailer, or other arm's length relationship in illicit distribution operations. And B, conspires to commit means that a person agrees with one or more persons that they, or one or more persons of them, engage in conduct that would constitute the offense, and that person and one or more of them perform an overt act in pursuance of the agreement. An agreement constituting conspiring to continue commit may be inferred from the acts of the parties. And C, profits means property constituting or derived from any proceeds obtained directly or indirectly from an offense listed in section 7102. D, criminal street gangs means 3 or more persons having a common identifying sign or symbol like the thin blue line, or an identifiable leadership who continuously or regularly associated in the commission of a crime, criminal activities. Texas Penal Code, Title 11, Organized Crime, Chapter 71, Organized Crime, subsection 71.01. A person commits an offense if, with the intent to establish, maintain, or participate in a combination or in the profits of a combination, or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. 1, murder, capital murder, arson, aggravated robbery, burglary, theft, aggravated kidnapping, aggravated assault, aggravated sexual assault, forgery, deadly conduct, assault punishable as a Class A misdemeanor, burglary of a motor vehicle, or unauthorized use of a motor vehicle. 8, any felony offense under Chapter 32. 9, any offense under Chapter 36. And 11, any offense under Section 37.11a. 12, any offense under Chapter 20A. 13, any offense under Section 37.10. 14, any offense under Section 38.06, 38.07, 38.09, or 38.11. 15, any offense under Section 42.10. 16, any offense under Section 46.0A1 or 46.1.4, or 17, any offense under Sections 20.05. Texas Penal Code 11, Organized Crime, Chapter 71, Organized Crime, subsection 71.01, and further. 13, the bar members' judicial thugs intended to compel their bar member representation by one of their bar member buddies so they can force their foreign jurisdiction upon their victims. In propria persona, in one's own proper person, it is a rule in pleadings that pleas in the jurisdiction of the court must be pled in propria persona, because if pleaded by an attorney, they admit to the jurisdiction as an attorney is an officer of the court, and he is presumed to plead after having obtained leave which admits the jurisdiction. Laws PI 91, Black's Law Dictionary, 4th edition, page 899 through 900. Boom, boom, boom. Where their so-called justice is a fraud. He is, however, in a sense, an officer of the state with an obligation to the court. His first duty is to the courts and the public, not to the client. And whenever his duties to the client conflict with those of as an officer of the court in the administration of justice, the former must yield to the latter. 7 Corpus Juris Secundum, subsection 4, attorneys, emphasis added. So they can convert their victim into a ward of the court. Clients are also called wards of the court. 7 Corpus Juris Secundum, 7 subsection 4. And a ward of the court is an imbecile. Wards of the court, infants, and persons of unsound mind, Davis Committee via Lonnie, 290 Kentucky, 64, 162, S period, W period, 2D, 189, 190. Their rights must be guarded jealously. Montgomery versus Erie Railroad Co., CCANJ, 97, F period, 2D, 289, 292, Black's Law Dictionary, 4th edition, page 1755. And these bar members intended to criminally convert their victim into one of their wards of the court, so the bar member thugs on the bench can collect their royalties and violate their victims' rights with impunity and put them in the warehouse jail, and their thieving bankster buddies can get rich too. The controlling rule is that, absent a knowing and intelligent waiver, no person may be imprisoned for any offense, unless he was represented by counsel at his trial. Arjun Singer, 407, U.S. at 37 P. 5 through 6, Alabama versus Shelton, 535 U.S. 654. When the trial of a misdemeanor starts, that no imprisonment may be imposed, even though local law permits it, unless the accused is represented by counsel. Agrasiner versus Hamlin, 407 U.S. 2540, 1971. And according to Earl Warner, former Chief Judge, U.S. Supreme Court, bar members are either incompetent or criminals. Between 75 to 90% of all lawyers are either incompetent, dishonest, or both. Earl Warner, former Chief Justice of the U.S. Supreme Court. And the practice of law is an occupation of a common right. But the bar members intend to deprive the people of that right, as evidenced herein. The practice of law cannot be licensed by any state. Sherweir versus Board of Examiner, 353 U.S. 238, 239, emphasis added. The practice of law is an occupation of common right. Sims versus Ahern, 71 SW 720, 1925. And further, bar members criminally convert your name under their Roman law, capitis diminutio, meaning the diminishing of the status through the use of capitalization. In Roman law, a diminishing or abridgment of personality or loss or curtailment of a man's status or aggregate of legal attributes and qualification. Capitis diminutio maxima, meaning a maximum loss of status through the use of capitalization. Ergo, John Doe or Doe John, the highest or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage when he became a slave. It swept away with all rights of the citizen and all family rights. Black's Law Dictionary, 4th edition, emphasis added.